Go forth. Continuing our education on the FEC, the Federal Election Commission. McConnell versus FEC. Status is closed. Summary. On December 10th, 2003, the Supreme Court issued a ruling upholding the two principal features of the Bipartisan Campaign Reform Act of 2002, the BCRA. We will read that later. The control of soft money and the regulation of electioneering communications. The court found unconstitutional the BCRA's ban on the contributions from minors and the so-called choice provision, which provides that a party committee cannot make both coordinated and independent expenditures on behalf of a candidate after that candidate's general election nominations. 1. The Supreme Court's decision affirmed in part a reverse, in part the U.S. District Court, the District of Columbia's decision in this matter. Background. Congress passed the BCRA in order to eliminate soft money donations in national parties and to ensure that the electioneering communication immediately before the election day are financed with regulated money and properly disclosed to the public. The BCRA, among other things, bans national party committees from raising or spending money outside of the limits and prohibitions of the Federal Election Campaign Act, FECA. Limits state and local party committees' use of such funds for activities affecting federal elections, prohibits solicitation and donations at national, state, and local party committees for the 501c tax-exempt organization that make expenditures in connection with the federal elections, and 527 organizations that are not federally political committees or state or local parties or candidates committees. Prohibits federal candidates and office holders from soliciting, receiving, directing, transferring, or spending soft money in connection with federal elections, and limits their ability to do so in connection with the state elections. Bans state and local candidates and officers from raising and spending non-federal funds for public communications that promote, attack, support, or oppose federal candidate. Defines and regulates electioneering communications. Implements the party choice provision, increases the hard money contribution limits, permits even higher contribution limits for candidates opposed by millionaires who use their own funds for campaign expenditures, defines coordination with a candidate or party committee, and bans minors from making contributions to federal candidates and political party committees. Most provisions for the BCRA took effect on November 6, 2002. As soon as the BCRA was enacted in March 2002, however, a number of parties filed changes for the constitutionality of the several BCRA provisions, including those listed above. These cases were consolidated around McConnell versus FEC and heard by a 3-judge panel of U.S. District Court for the District of Columbia. On May 2, 2003, the District Court determined that the certain provisions were constitutional, while a number of other unconstitutional or non-justiciable. The District Court issued a stay of its ruling on May 19, 2003. While the case received an expedited appellate review by the Supreme Court. Supreme Court decision. National party committees use of soft money. The BCRA bans national party committees and their agents from soliciting, receiving, directing, or spending any funds that are not subject to the FEC's limits, prohibitions, and reporting requirements to USC, that's United States Code 441A1 and 2. The court found that its U.S. provision did not violate the Constitution because of the government interest in preventing the actual apparent corruptions of the federal candidates and the office holders that were sufficiently important to justify the contribution limits. The court noted that the record is replete with the examples of the national party committees peddling access to federal candidates and the office holders in exchange for their large soft money donations. The court was also not persuaded by the plaintiff's arguments that this provision of unconstitutionality interferes with the National Party Committee's ability to associate with state and local committees. The court found that nothing on the face of the provision prohibits National Party officers from sitting down with state and local party committees or candidates to plan and advise on how to raise and spend that soft money, so long as the national officers do not personally spend, receive, direct, or solicit soft money. State and local party committees often use soft money. The court also upheld the BCRA's limit on state and local party committees' use of soft money for activating activities affecting the federal elections, finding that the provision was closely drawn to the match of the government interest in preventing corruption and appearance of corruption. 2 U.S.C. 441IB. This provision of the BCRA provides that state and local party committees cannot use non-federal funds to finance federal election activity, FEA, which is defined as 1. Voter registration activity during the 120 days before an election. 2. Voter identification, get out of the vote, and generic campaign activity conducted in connection with election in a federal candidate appears on a ballot. 3. A public communication that refers to a clearly identified federal candidate and promotes, attacks, supports, or opposes that candidate. And 4. The services of a state committee employee who spends more than 25% of his or her compensated time in activities connected with the federal election. Instead, party committees must finance these activities with federal funds, or in some cases, they may finance them with a combination of federal and levin funds, which are a new category of funds defined in the BCRA. 2. The court found that the Congress had concluded from the record that soft money's corrupting influence insinuates itself in the political process not only through the national party committees, but also through the state committees, which function as an alternative avenue for precisely the same corruption forces. The court concluded that preventing corrupting activities from shifting wholesale to state committees, and thereby adversating the FEC, clearly qualifies as an important government interest. Dun, dun, dun. The court further determined that the fact that FEC captures some activities that affected the campaigns for a non-federal office is not sufficient to render the provision unconstitutionally overbroad. Activities that are considered FEC or under BCRA were also covered by the pre-BCRA and allocation rules, and the court concluded that, as a practical matter, BCRA merely codifies the FEC's allocation regimen principles while justifiably adjusting the applicable formulas in order to restore the efficacy of the FEC's longstanding restriction on the contribution of state and local committees to the purpose of influencing federal elections. The court determined that the first two types of FEC listed above substantially benefited federal candidates by encouraging like-minded voters to go to the polls. The third type of FEC, including public communications in support of or opposed a federal candidate, directly affected the election in which the candidate is running, and the regulation of the funds used to these communications is closely drawn to anti-corruption interest and intended to address. Similarly, the final FEA regarding the payment of final committee staff is justified by Congress' interest in preventing circumvention of the law. Lastly, moreover, the court found in the 11th Amendment to be constitutionally insofar as the association burden it created with a restriction on the transfer of the levin funds between the party committees are far outweighed by the need to prevent the circumvention of the overall scheme. Additionally, the court determined that evidence suggesting that the levin fund restriction might prevent parties from amassing the funds needed to make themselves heard was merely speculative.